everyone. It is Monday, June 30th, 2025 at 6:01 p.m. and I will call to order this evening a special meeting of the Millwood City Council, where City Council is sitting in session acting as an appeal hearing body on a code-related matter. Because this is a special meeting, tonight's agenda is fixed, but I do want to call attention to action item 3A, where it says closed record appeal hearing. That is an oversight. This is not yet a closed record. Will not be closed until such point a decision is rendered. So right now we are simply in an appeal hearing. You may cross out closed record on that. So at this time, we'll move to a roll call. What I have tonight, though, is a request from Shauna Beasy, who has a previously scheduled vacation, to ask for an excused absence from this meeting. Is there any council member who would like to excuse Ms. Beasy from this meeting?
I would excuse Ms. Beasy.
Is there a second?
I'll second.
Moved and seconded. Any discussion? Seeing none, all in favor of excusing Ms. Beasy tonight?
Aye.
Any opposed? Hearing none opposed, Ms. Beasy is excused by council for tonight's meeting. And so at this time, would you please call roll?
Yes, I vote. Council Member Stevens?
Present.
Council Member Sander?
Present.
Council Member Van Hees?
Here.
Council Member Kohler?
Present.
Council Member BC is excused. Mayor Freeman?
Here, present. So we have a quorum of the members of the City Council here to act as the hearing body. And as such, we can go ahead with this meeting. And so at this time, I'd like to lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. And so tonight we are opening with the appeal hearing on an administrative decision rendered by the city for a fence permit at 9011 East South Riverway. We will begin by hearing the appellant, Mr. Joe Ward. And Mr. Ward, you have 15 minutes to address the hearing body. Please approach the podium, and if you would mind stating your name and address for the record.
My name is Joe Ward. My address, my name is Joseph G. Ward. My address is 15102 North Tormey Road, 9 Mile Falls, Washington. Okay, to go?
Please.
I turn 77 and a half tomorrow, and that half a year is very valuable to me. And as time goes on, boy, that clock's an awful big one. As time goes on, I've really noticed here that I just can't handle things the way I used to. What I wanted to do is I started trying to address the so many pages in the appeal and writing notes down, and then I found out after I read that I was only going to get 15 minutes, and there was no way that I could present everything in 15 minutes. So what I decided to do was to go in there and where Amanda put it in blue, I was going to do it in red, and I had spent 3 or 4 hours doing that, and I'm going, well, this ain't going to work. So then I decided what I was going to do is what I've given everybody a copy of, which is a little bit of a speech. It's read along with Joe night here, okay? Now, last time I came in here was, I can't remember the date, doesn't make any difference, but it was 4 or 5 months ago, okay? And I came in here because I wanted to share with you that I was having difficulty communicating with the staff, okay? And I thought I was going to get a few minutes, and 3 hours later, after listening to everything, leaky pipes and historic this, that, and the other thing, I got up there and was told I had 2 minutes. And I couldn't explain things in 2 minutes like I can't explain things in 15 tonight. So what I did is I went back, to what the mayor told me, go back and deal with the city staff. But it's very difficult dealing with city staff when they're not attorneys and they're reading things and they're supposed to interpret things. And when they interpret the law, your law, there's many things that are fuzzy wuzzy. You know, for example, and I'm not reading off of this yet, but for example, because I'm in the shorelines management area, all of my property except maybe 10 feet along the road, 15 feet, okay, it states in there clearly that I'm exempt from all these permits and everything for normal routine maintenance and repair. Real clear. And then the first, it's real clear. And what happened, I'm just going to start reading now because it's time to do it. Good evening, Mayor Freeman and council members, and Amanda and Lisa. I've been in real estate since 1970, and in all those years I pride myself being a good steward of my properties. The apartment located at 9011 East South Riverway is the best looking and best maintained apartment building in Millwood, something I've worked at very hard to achieve and maintain. After 50 years of responsible property ownership, why are we at odds with each other? What I am here to ask tonight is for simple, help me finish restoring my property from the devastating windstorm damage, not through legal battles or code violations, but through reasonable interpretation of existing ordinances that allow for storm restoration, upgrades to existing structures, and normal maintenance and routine. The first one there is perfect storm circumstance. In January 2020, when we were hit by a catastrophic windstorm that caused massive property damage across Spokane, at my properties alone, in three municipalities in Spokane County, I had 50 trees toppled, 10 plus roofs damaged and leaking, broken water lines, plugged sewer systems, sprinkler damage, shattered windows, the list goes on. All of this happened during COVID. While government offices were closed, there was no labor pool, and contractors were 8 to 12 months out providing a bid, if at all, and insurance companies were overwhelmed with claims. I did what any responsible property owner would do. I prioritized repairs by urgency, tenant critical items first, windows, heat, water, then moved to exterior work as workers became available. The massive tree that fell across our property and onto the Oregon Road Bridge and destroying 8 to 10 other trees. Just to remove that one massive tree took over a month and cost $28,000, not counting repair costs. That tree removal took place on a Sunday and shut down 2 lanes of traffic on the Oregon Bridge. Where are we today? I'm not asking for special treatment. I'm asking for what every property owner deserves. Reasonable interpretation of ordinances and opportunity to restore my property to its pre-storm condition, upgrades, and normal maintenance and routine included. Unfortunately, the city staff's approach to what it has been to weaponize the municipal code against me rather than working collaboratively on legitimate storm restoration. The targeting becomes evident when you consider that other property owners completed their storm restoration without facing this level of scrutiny, delays, or arbitrary interpretations of municipal code provisions. The fencing I've installed isn't new construction. It's restoration and improvement of existing barriers. Denied was the replacement of a 6-foot wooden fence that extended from my apartment building to the street. In addition, there were established shrubs, trees, and boulder formations that your own ordinance defines as fencing. You and I have photographs and documentation showing that they existed before the storm, which the staff refused to consider even after they received photos of evidence. The core issue, weaponizing the municipal code and targeting. Despite requesting on-site meetings countless times, not once or twice, and that was the reason I wanted all those emails put into the record and provided, is that I can't even tell you how many times I asked for an on-site meeting so we could go over what was going on down there and what required permits and what didn't, what's considered normal maintenance and repair. And I was refused at every single one. Never once did the staff meet me down there. The only time that I know the staff was down there was one of the staff members went down and my property manager came out and asked her what she was doing, and she turned around and walked away. Wouldn't even acknowledge that she was taking pictures and wouldn't even acknowledge who she was. this is the effective, there is effectively nobody to communicate with at staff level. Amanda, I can't, is it Tanya? Tanya is a part-time contractor planner who consistently weaponized the Millwood Municipal Code against me rather than working collaboratively. The pattern of targeting becomes clear when you examine the sequence of events. And this goes before what we're here to talk about today. The first stop work order that I received was posted at my property regarding replacement of the wooden portion of a dock. The dock is comprised of about a 100-foot seawall with concrete pillars out in the lake, for which I took out a permit 30, 40 years ago. Posted on my property on May 10th, 2023, which is clearly exempted as normal maintenance and repair under the shorelines management portion of the city code. It took weeks to hear back and required 50+ pages of documents to be submitted for work that was clearly permitted and exempted and was stated as normal maintenance and repair in the city's findings and as clearly exempt with no other requirements or suggestions for any further permits. The second one is the stop work order. The second stop work order. This was followed by another stop work order regarding the retaining wall near the river, posted April 8th, 2024. More delays, more paperwork, again, for work clearly exempt under the shorelines provisions, and again, restoration of a retaining wall, which was determined to be normal maintenance and repair by the city. But the fine print on this second approval states under conditions, all other regulations or permit conditions of approval, whether mentioned in this exemption or not, shall be the applicant's compliance responsibility. So I'm supposed to understand what this is. What do? I call the city and say, hey, would you kindly come down here 2 blocks away, look at all this work that I'm doing, and tell me what is normal maintenance and repair? What requires a permit? What doesn't? Because I'm tired of getting these stop work orders. I have always, in my 50-some years in business, have always tried to take care of problems on the front end, not the back end. And that's what I'm doing here right now. And it's bothersome, to be honest with you. Systematic denial of communication. Each stop work order has caused unnecessary delays and additional costs. When I requested clarification and on-site determination, on-site visit to determine what other permits might be needed to inspect ongoing storm work repair and to clearly define what was normal maintenance and repair, not requiring a permit, such as weeding, lawn mowing, edging sidewalks, watering the lawn, all of those things we obviously say are normal maintenance and repair. But now there becomes a finite thing. When do I need a permit and when don't I? Again, no response, blew me off. I was summarily rejected each time. My emails show numerous unanswered questions for basic communication, arbitrary interpretation. I believe that Amanda, when she looks at whatever's there in the ordinance, does exactly what it says and doesn't interpret it in any way, shape, or form. If it says that, that's it. And there's no room for interpretation. As requested, I presented an application for fences, including a map of the property showing the fences in question and why they were permitted under the existing ordinances. Without any discussion or request for evidence supporting my position, Amanda denied my request for portions of the fence. This felt arbitrary and further supported my belief that the municipal code was being weaponized against me. So what I did is I said, okay, I'm going to turn in an amended and restated permit. And I asked twice. I asked Mayor Freeman if I could work with and have discussions with the city. And I also asked for that in my cover letter because I needed to know. And I needed to know what I was going to not have to have a permit on and what I did. For example, when you talk about the barbed wire on top of the fence, that's something I added to the amended permit. And I was turned down. I was not allowed to give any evidence whatsoever. And when I finally got the meeting that I requested of the city so that we could go over that permit and talk about those things, they absolutely would not let me talk about anything else. And these are your two things you have to do. You either file an appeal to the city council or you file for something. I'm going, wait a minute. I can prove. She says, you didn't turn anything in. I'm going, wait a minute. I asked for a meeting ahead of time so we could talk about it and I could provide evidence, and I was denied. False accusations. One of many examples, I received a terse letter from the mayor stating that I continued working on the fence after receiving the infraction. I did not. And I can prove irrefutably to the contrary. I suspect the basis of the claim came from staff. I've got a picture taken 2 days after they went over and visited my site with all the fencing in place, and I didn't receive the stop work order for another 3 days. So I have a very difficult time working with staff and trying to get anything done. And now I've been hit with another complaint. And I'll have to fill out another 40 or 50 pages. And all of this could have been prevented if I had somebody I could sit down and talk to and say, what would you like me to do? I have always done that. Does that mean I have 1 minute left? I was hoping it was just starting, and I just started in on my 15 minutes. I'll go a little quicker. MCC authorized Samantha to interpret law even though she's not an attorney. Unfortunately, she weaponizes the code through selective interpretations and creative, nonsensical definitions that appear designed to create obstacles rather than facilitate legitimate maintenance and repair acts of God, restoration, and exemptions. And since I only have a minute, I'm going to go right to the last one. Because this is what I'd like to see. Moving forward, end the targeting, support property owners. That's on my page 5. I don't know which one it is on yours. I had to have big print so I could read it. The weaponization of the municipal code against legitimate property owners sets dangerous precedent for Millwood. Public servants should help property owners maintain safe, attractive properties that benefit the entire community. When someone is trying to do the right thing, restore storm damage, maintains tenant safety, preserve neighborhood appearance, and perform routine maintenance and repair, the city should be a partner, not an adversary engaged in systematic targeting. This targeting approach not only harms individual property owners, but undermines confidence of fair and consistent code enforcement through Millwood. Property owners should be able to trust municipal codes will be interpreted reasonably and applied consistently, not weaponized based off of staff preferences or biases. I spent 56 years building a reputation as a responsible property owner. I invested significantly in making 9011 East South Riverway a showcase property. All I'm asking is for the opportunity to complete the storm restoration. I respectfully request that you approve the fence work and grant the necessary permits to complete the restoration of my property. Let's work together to ensure property remains an asset in Millwood for years to come. Thank you.
So sorry.
That's all right.
So sorry. I exited out and out.
Rosina told me that I should read this thing first and see if I could get through it in 15 minutes. I should have taken it.
You did pretty well. Not too bad.
Now I gotta refind it.
So that brings us to,
So when do I get to go through all those papers in front of the mayor over there?
That's your step.
this is what we
Well,
printed.
I meant to explain it to the whole staff here. Never.
It's been submitted, it's up to them to read. So,
And Lisa, when you get a chance, do you mind pulling up page 3 of the staff report?
Yes.
so let us, is that the only example you'll need? Alright. So when that is up, we will begin the city's 15 minutes for response.
I'm gonna try and get the timer back
Okay, you got the
because
timer?
I exited out of it because
Yeah,
I
it's
quiet. So let me get it back. smaller, maybe, try to a little bit. So we can still fit the other. And put that in there. And we get this a little bit bigger. Good thing it goes away, sure. There it is. Got it.
Got it?
Yeah. Get this over here first and then this back. Oh, there it is.
Can I offer a suggestion? Let's see this real
There
quick.
it goes.
Hang on.
Thank you, sir.
Let's minimize this real quick. I do take a tip.
Better find a better job. Need sound remember, as chairman, I used to do this. For every meeting, make sure everyone has water. You gotta sell some of those, condos over there.
I can't make it larger.
Thomas
on the
George
screen,
Tower.
but it-
You said it's okay. I see everyone has it. I can reference it.
It's right here.
There's a commercial space underneath.
I'll bring it.
Yeah.
Okay, you can bring that over.
And at the other one, at the Sherman Tower, they're gonna have commercial space on it. We'll talk.
All right.
You said?
Are we ready? So we will begin the city's response from Ms. Foster.
All right, thank you, Mayor, City Council members, Mr. Ward. As the Mayor said, my name is Aziza Foster, Mickey Jackson Buyer. I've been retained by the city to help them in this manner. While I appreciate Mr. Ward's arguments, I kind of want to recontextualize and refocus City Council on why we're here. This is the appeal of a denial of a building permit application. And specifically, the denial aspect that we're talking about, it's on page 3 of the staff report. It's also up there on the screen. You're talking about the areas in red. And what it is it is a 6-foot tall wrought iron fence that is along the front and front side yard of Mr. Ward's property within that 25-foot setback area. And under the Millwood Municipal Code, all front and side yard fences must be 42 inches. That is what the code says. Mr. Ward does not deny that that is what the code says. Mr. Ward also does not deny that he initially constructed that fence without a permit. He was cited for that. In that warning notice, it told him, you've constructed this fence without a permit. This fence is also over 42 inches in height. Those are the 2 violations he was cited for. He comes in, he submits a permit application. It's initially denied. We go back and forth with the city. The city is telling him, this is what you need to do. These are the violations on your property. Here are your options on what to do. He ends up submitting an amended permit application, what you see up there, with the same faults present, namely the 6-foot wrought iron fence. And additionally, I'll get to it in a little bit later, but he's also proposing a fence around a dumpster. However, it is also 6 feet tall and within that 25-foot yard setback. So as I stated, those are kind of the key facts that weren't denied. We have a 6-foot fence in a front and front side yard as prohibited under the municipal code. Instead, Mr. Ward claims that he has a non-conforming use that should be grandfathered in. He bases that off of 2 features, I'll call them. One would be a 6-foot cedar fence that was along the west side of his property, and the other were juniper bushes and some boulders that were more along the front and then into the front side of the property. And I'll address each of those in turn, but I kind of want to just provide an overview for council of what the non-conforming use law is. The first is that the burden of showcasing a non-conforming use is on the person who's claiming that non-conforming use. So in this case, Mr. Ward has the burden to prove to you that he had a non-conforming use. Now, what is a non-conforming use? In simple terms, a non-conforming use is one that was legally or lawfully established prior to the enactment of a zoning ordinance that then prohibits whatever that use was. So essentially, Mr. Ward has to prove to all of you that he had lawfully established essentially a 6-foot fence in that front and front side yard area. Otherwise, it is a violation of the code. Now, I said I'll address that 6-foot cedar fence. The city does not dispute that that 6-foot cedar fence existed along the west side of the property. The issue is that there's no evidence that that 6-foot cedar fence, encroached into that 25 foot front yard setback. You see that in the photos from Ms. Tainio, in the staff report. You even see it from the photos that Mr. Ward has submitted. It just never encroached into that 25-foot setback, and it certainly never encroached into the front side of his property. Now, to the extent that it may have at one point encroached into that 25-foot setback, it was never permitted. Permits have always been required since 1961. That comes from Ordinance 54A, which I noticed is not in the staff report, and I have copies that I'll hand out to all of you at the end of my presentation. Mr. Ward admits that he has never had a permit. It's in his April 29th, 2025 at 12:27 p.m. email. It's one of the various emails in your packet that he's never gotten a permit. If a permit is required and he's never received a permit, it cannot be lawfully established. Additionally, since 1955, all front yard fences have been subject to that 42-inch requirement. That is Exhibit M, Ordinance 46. So even if that 6-foot cedar fence did exist in that 25-yard setback, it cannot be deemed legally established because it was in violation of the code at the time. Quickly on the juniper bushes and the boulder wall, the city does admit that at one point in time, Ordinance 299 would have allowed hedges and shrubbery that serve the same function as a fence to be considered a fence. Now, there is no evidence that those juniper bushes and those boulders were, within that 6 feet. That's what we're talking about here. Did he have a 6-foot fence at some point in time? You see the photos. I'll cite you to, pages 9 and 12 of the staff report. You can see what those look like. And importantly, you can also see that they did not serve the same function as a fence. They are landscaping features. They do not provide a physical barrier preventing entry into property. They're just landscaping features. They cannot establish a legally non-conforming use. Mr. Ward, and understandably so, he makes a lot about the windstorm damage in 2021. I don't dispute that his property was affected by the windstorm at all. However, the evidence from Mr. Ward relating to that windstorm shows a couple things. One, it shows that the cedar fence was repaired all the way back in 2022. Point you to, I believe, page 11 of the staff report should kind of...
Could you say that one more time? It was all what in 2022?
Whoa. No, Dot, you don't get to interrupt during this time. So, stop. Just pause that for a minute.
Reset the clock.
No. So put in...
I had 9 minutes left.
No, you had 9 minutes, 45 seconds. Got those. Those are hours.
Gotcha.
I could go for 9 hours, but I don't think anyone would like it.
No, nobody wants that. Nobody wants
We
that.
need a bathroom break.
I can filibuster.
Sounds good. And go.
So as I was saying, what the photo shows, specifically page 11 of the staff report, shows that by at the latest in 2022, that cedar fence was replaced. You can also see it in the construction bids that Mr. Ward submitted. I believe those were dated in March of 2021. So that fence was already replaced, and you can see very clearly from those photos that they do not extend into that 25-foot setback. Once again, there's no evidence of a permit on file for those. Additionally, under the Millwood Municipal Code, specifically 1738-020 sub D3, if this had been a non-conforming use and it was damaged by an act of nature, which I will concede the windstorm was, that repair shall be initiated by issuance of a valid building permit within 1 year of damage. That wrought iron fence that was in fact constructed, that construction did not start until the end of 2024, more than 3 years after that cedar fence had already been damaged by the windstorm. And also, I'll just mention again, that cedar fence never encroached into the footprint of the wrought iron fence. When it comes to the dumpster, I know Mr. Ward didn't get into that too much, but it was in his appeal application. Namely, the permit for the fence on the dumpster was denied because it's proposed to be a 6-foot fence. However, it's in that 25-foot setback within that front side yard fence setback. As to the barbed wire, I'll just point you to Exhibit O, which is Ordinance 387, which starting in 2009 had prohibited barbed wire for fencing. We have not seen any photos that there was fencing predating that ordinance with that barbed wire. I acknowledge there are photos from 2011 with that barbed wire, but once again, that ordinance was enacted in 2009. So our position is well stated in the staff report. Simply put, there is no evidence that there was a lawful non-conforming use existing within the footprint of that fence permit or that wrought iron fencing so as to support a non-conforming use. I just want to highlight, Mr. Ward brought up some concepts regarding the Shoreline Management Act and permitting for that. I'll just note that the Shoreline Management Act, or the requirement to get a permit or an exemption from a permit, does not apply in this case because we're just talking about a fence. Additionally, the exemption would only exempt him from getting that shoreline permit. It wouldn't exempt him from the fence permit requirement. And lastly, even if he was exempt, he still would have to apply for the exemption. And that's kind of one of the issues here, is that none of this work had ever been applied for until the city, through its code enforcement, had happened to stop by and see it and then start its code enforcement process. And so that really is all I have before I turn it over to Ms. Tinio to give you kind of a bit more factual context, unless City Council has any questions for me. All right,
Okay.
Ms. Tinio.
So I will go ahead and pick right up. Clarification I wanted to make on Mr. Ward's testimony is that I began contracting with the city in August of 2024. Prior to that, the exemption that was issued in 2023 was under Ms. Jansen, as was any correspondence. My first correspondence with Mr. Ward came in April of 2024 when he again received a code violation for work in the shoreline, worked through that with him, and was able to grant an exemption for that work. Fast forward to the fall of 2024 when it was discovered the work on the fence. It was guided at that time that it couldn't be approved and what needed to be done. He could apply for a variance. We were guided on that, or he could apply for an appeal. We did sit down with Ms. Castles, and I sat down with Mr. Ward in March of 2025 to go through this. And then he subsequently submitted the restated application in April, which is the highlighted version you see here. The portions highlighted in red were what were denied. The portions highlighted in yellow and orange were determined to be outside the scope of the permit application, and the portions in green were approved. Can you go to the page 11 or 12 of the staff report again? And then subsequently, Mr. Ward filed the appeal. So Ms. Foster did a fantastic job of going over everything. I just want to reiterate a couple things. Again, the 6-foot fence, no evidence was submitted to show that the fence goes all the way to South Riverway. It doesn't even show that it went exactly to the utility pole, and the new fence goes all the way to South Riverway. So the pictures you see on the screen up there were submitted by Mr. Ward. They're pictures J and K, and they clearly show that it did not go all the way to South Riverway. Ms. Foster already addressed the junipers, so I will not cover that portion. And I will go into a little more information on the denial of the dumpster enclosure. So again, if it is within that 25-foot and it's part of the setback, it has to be the no more than the 6 foot, or sorry, no more than 42 inches tall. The dumpster enclosure would be considered, if it's approved or applied for at 6 foot, it would not be allowed. It was not approached to us or stated prior to this appeal that there were any safety hazards nor any concern from waste management. Regardless, a 6-foot tall site obscuring dumpster enclosure cannot be located within the 6-foot or the 25-foot front setback area. Based on the evidence provided by the appellant in the appeal packet, the barbed wire did exist in 2021, as stated by Ms. Foster, and as early as 2011. However, nothing was provided to show it legally existed prior to Ordinance 387, as she stated. A fence, as also is not a regulated use in the shoreline residential designation and therefore could not fall under the normal maintenance and repair exemption. Item 6 on the 421 decision identifies that the 8x8x20 replacement storage unit that's highlighted in orange on the site plan I previously showed cannot be reviewed under a fence permit application, so a separate residential site plan and design review would be required for that. That issue is beyond the scope of the appeal. The city has reviewed the documents provided by the appellant, and the city's position remains that the unpermitted construction does not qualify as a non-conforming use, and that the city applied its code correctly. Are there any questions for me?
Mr. Sander?
I have a question. What, on the lower right-hand side, the green part, something has been approved. What was that?
It was 42-inch tall chain link along there.
Thank you.
Yes.
Mr. Culler and then Mr. Straves.
How tall is the existing chain link along Argonne? The shorter, is that 42 inch?
As stated in Mr. Ward's, yes, it's 42 inches. Yeah. Now, further up the side, I did not measure it, but it appeared to be between 42 and 48. It was outside of the 25-foot setback, so it was fine.
Mr. Straves.
That 42 inch has been in place since 1955.
It's 55. Yeah, and that is, I can give you the ordinance site. That was ordinance 46, and that's exhibit M in the, in the staff report.
And we've consistently enforced that.
Yes.
Yes.
Well, I can only speak for myself. I have.
And how far, excuse me, can I ask another question?
Yes, Mr. Culler.
How far up the west side here does the existing cedar fence go? It doesn't go towards, it doesn't get to the utility pole out there.
Yeah,
It's out their way.
a dimension was not specifically provided, but based on the information for replacement, it gave an approximate length, which I measured, and it did not come
Within the setback.
Yeah, it may have slightly come within the setback, but it did not come to the street for sure.
So the replacement cedar fencing from the contractor information provided by Mr. Ward stated that they replaced 88 feet of cedar fencing. I believe if you look at the staff report, the distance from the back side of that 25-foot setback to the end of Mr. Ward's property was measured at about 181 feet on Scout. So you're looking at it's about 88 feet into, and then I believe there's chain link fence up until that wrought iron fencing.
Any other questions for city staff? So at this time, does this hearing body have any questions of Mr. Ward?
We gave Mr. Ward 5 minutes
Oh, for rebuttal. Sorry, thank you. So, Mr. Ward, you have 5 minutes to respond to the city's presentation.
I instructed my people behind me to pull me back and set me down if I get too worked up. But are you a city councilman? Or are you?
I was an attorney retained by the city to help them in this matter.
Okay. Let me. Both of you did exactly what I thought you would do, and I'm very happy you did it. You did not try to help in any way, shape, or form for me to go out there and finish my project. Period. End of statement. You come up with all these side issues that really don't mean it. The first thing is that the burden of proof is on me. I'll grant you that. But you did not give me the opportunity to have a meeting with you, and I asked the mayor, I wanted to work with city staff, and I sent you a letter,
Mr. Ward,
asking.
address it to us.
I asked in that.
No. They're the hearing body. Talk to them.
The hearing body.
I'm sorry. I'll talk to you only.
Politely.
Thank you. I asked for the letter, in the letter, to have a sit-down meeting to go over the permit that I asked for, and I was denied. I have never had a meaningful meeting with the city at all in any way, shape, or form, and they claim there were numerous meetings. The only meeting that I finally got was after the staff had given their determination of what was there, and I had no opportunity to do anything. I had evidence that I was prepared to give her, and she said, nope, you got this way or that way. Those are the only two things. I'm sitting there looking at it. The violation, the burden is on me. Well, I had lots of proof. The two pictures that you see right there, if you look at that one picture right there on the top, that top picture, you can see the wooden fence going all the way up and beyond those two cars in the picture. Second thing is, the reason you can't see it, and beyond that, is the junipers and the trees behind it grow over the top of the fence, creating an impenetrable fence. I have never seen anywhere in any law book or definition of a fence having to be a certain length. Just because it has a void in the fence doesn't make it a fence. If you go right over here to West Valley High School, there's all kinds of entrances that are there, and a fence there's never in a definition a determination of length. So using that as an excuse that those junipers were not a fence is ridiculous. In addition, those rocks provided a barrier there. And I asked for help, and I got none, zero squat. The building that the property owner next door, that fence over there, was built, I think, in 1956.
51.
Pardon me? 61? 1951. Okay? So that fence whatever, I can't even remember terms of art anymore, predated any code that said you had to have a fence of a certain height. The next thing is it is a physical barrier. A fence is a physical barrier. In addition, it defines in your code exactly what a fence became. I forgot the date of it. That code, I quoted it in there, and it said that hedges, or made out of any other material are now considered fences. So I wanted to be able to sit down and be able to describe that. I also called the city's attorney and to sit down with him and talk about legal stuff. No return phone calls, period. None. In fact, I got about 10 of them there where he was on vacation, and so I said, well, I've called him enough, he'll call me back.
1 minute.
1 minute. Barbed wire fence. I had pictures, and they're submitted even after now when we're here right now, and they were submitted to you. They're still trying to say that there was nothing submitted to them. There's all kinds of pictures in there showing that barbed wire fence going across there. I did nothing more than repair a fence that the county wouldn't repair. I even cut down the tree off the bridge that was on city or county property. Now, the city of Millwood did cut the end down. I went running out there because I heard it was sticking out in the middle of the road by 30 feet. By the time I got there, they'd already cut the end of it off. But there's exemptions in the code that permit these things. And I'm astounded that they sit here and we want to just fight. Though, if you turn around and look at those pictures there, those are considered fences or should be interpreted that way based on the code. There's a triple fence going across there. If we look, if I'm able to point here, the only reason there's a void here is because we had to dig down in there and get to the water meter because something was all screwed up on it. But this thing went all the way around. Look at those trees. And you can see that this fence continues on. Why would I stop it back here where the edge of the tree is? It's ridiculous. And it just really annoys me that, I can't sit here and work with a city and there's nobody in between. There's nobody in between Amanda and the city council that I can talk to. I'm used to going through and working up through a chain of command and be able to sit down. But this is a fight now. This is a fight. There is no interpretation about anything.
Thank you.
You're quite welcome. Do you have any questions?
Does the council have any questions for the appellant?
I do. So, Mr. Ward, I'm confused by the rocks. So you're saying, how do the rocks play into a 6-foot fence?
They didn't.
But
They didn't play into a 6-foot fence, okay? Those rocks are a fence. You can't get by them with a car. If you look down there, if you look at the rock down here, you can see where cars have hit it. It used to be up here. Right, Quinn?
Rocks are a delineator, but they're not a fence. I mean,
Pardon me?
Rocks are a delineator, but they're not a fence. You can
Well,
walk
if
around.
you read the code, if you read that portion of the code that you passed, and it says hedges, blah, 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 or any other material that is used as a fence is a fence. Now, all I wanted to do is to talk to somebody and sit down. How can we resolve this? What can we do? But nobody would talk to me. So I went about my business of completing all the damage that was done out there. And I have another one facing me now, which I have no problem. And if you notice, every single time that I'm given a red tag, can you imagine that? A stop work order. Most people come up and say, hey, Joe, I think you got a problem here. Let's talk about it. No, they stop my work, and I go in there and immediately fill out all the forms for them,
Mr. Ward,
get it approved.
we're in the question and answer period.
I'm
now,
sorry.
so-
I have a question. So
Mr. Stevens,
when you came to staff, did staff tell you that within that 25 foot, it has to be a 42 inch?
I'm sorry, can you repeat that?
Yeah, so within that 25 foot, did staff inform you that it has to be 42 inches? When you applied for that fence?
Well, when I applied for it was after the fence was already up. Okay? I mean,
So
they give me
we
no
have
choice.
codes. So why did you put a fence up? When we have codes in Millwood, why did you put a fence up?
Okay,
Why didn't you come to staff and we would have told you that
No,
it's
it's not true.
42 inch?
I tried that, and they won't talk to me. They won't meet me down there.
Thank you, Mr. Ward.
thank you, Mr. Ward.
Thank you.
Any other questions for Mr. Ward at this time? Thank you very much, Mr. Ward. We appreciate you coming in. So that closes our presentations. No. So at this time, we have the hearing body deliberation and a possible decision. I would ask council or the hearing body that given the amount of documents that have been provided and the testimony you've heard tonight, do you wish to begin deliberations now, or do you wish to take this under advisement and then reconvene at a later time with a discussion?
I'd like to proceed tonight. Council, you'd like to do what? Proceed tonight. Should we do conflicts?
So, yes, so prior to council or the body taking any action, Mr. Ward did have an invitation for council members to personally inspect his property before tonight's meeting. Has any council member here availed themselves of that opportunity?
No.
Not since the appeal was filed.
Not since the appeal was filed. But you did not personally go tonight based on the email that I forwarded on to folks today? Okay. No, you go ahead.
So getting to Councilmember Straven's point, since you're sitting in a quasi-judicial setting, I think the question that's being asked is appearance of fairness doctrine applies. And I think what we just need to make sure is that if any council member has had any ex parte communications, any information that hasn't, or would be in a position to make a decision tonight that would not be based on the information presented to you in writing or by testimony, to provide you the opportunity to disclose those on the record if there is such that could question your involvement. I'm here strictly in the role of a procedural and for the city of Millwood. The reason that I am not participating in this as legal counsel is of a potential conflict of interest with Mr. Ward's representation by other members of my firms. That's why I'm not participating in this process except for the procedural aspects under our city code. So,
Does anybody have any ex parte communication or any other activities they wish to disclose that might render them with a conflict? So hearing none, I will turn.
the public as well.
Huh?
Public has an opportunity to express if there's any appearance of fairness doctrine concerns.
You can spit that one.
Okay. Is there any member of city staff or anybody from the public that's in attendance that has anything to disclose or of concern regarding any of the members of the city council to sit in a decision-making position. Okay, we'll allow the silence to reflect none.
So, at this time, that turns deliberations over to the council hearing body. So, gentlemen, you may begin. Anybody wish to begin speaking?
So I'll start. So 17 years playing at zoning. Since 1955, we had a clear ordinance for fencing. So it's a 25-foot setback. We have 42-inch limit. Mr. Andy served on planning and zoning. It's been consistent. There's been very few, if any, that I can recall variances for that. There's good reasons for it. It's established in Millwood. Millwood's proud of being different for statues, right? I don't know if that's consistent with Spokane. I don't care. We're Millwood. We've had 25-foot setback for 42 inches. It's very clear. It's very established. Rocks certainly don't establish a fence, in my opinion. Certainly not to go up to 72 inches. So 6 foot is 72 inches. That's substantial. We're not talking 2 or 3 inches. We're talking the difference of 30 inches. So this is not complicated, in my opinion. This is education for property owner that we actually have rules and regulations and know what must be followed. It's clear to me.
I can't recall ever granting an exemption for the 42-inch within 25-foot setback since 2008. Can I question staff on that?
I'm not sure that Amanda would know.
Oh, because she's only been here for 2024.
Yeah, I can speak to being here since 1998, and I was the recipient of a violation to make my fence 42 inches after a year of living here, which I needed to comply with. So as far back as 1998, the city was actively enforcing.
Well, the key is not getting a permit at all.
Right.
So, I mean, in the permitting process, you would document what you're gonna do with height and then we would give, no, you can't do that, you have to do this is what the code says. But we didn't get that opportunity.
That's the opportunity that staff would have to then cooperate with the property owner to educate them as to our municipal code. So without a permit, it makes it very difficult for staff. And once you do something, and then you'd like to ask for forgiveness and come up with reasons like rocks make a fence, that's difficult reasoning for me to do.
It's also a precedent we don't want to establish either,
That's very true.
as we have denied these applications in the past.
Right, consistently.
So what are we thinking?
Councilman Sanders, do you have thoughts?
Well, I think the permit business, if before the wrought iron fence was installed, if we came in, sat down and said, here's what we want to do for permit, this would have been discussed. Now, there may be an issue with the height, but the fact is, there's no permit. That's the hardest thing to get around. That's the bottom line, there's no permit.
There's no.
And it's hard to see, and this goes to a little deeper than I think the big no permit issue, is it's hard to see in that picture just how far that cedar fence really did go on the west side. But that's the second issue. The first issue is there's no permit.
And as council pointed out, there wasn't a permit for that fence. So if it did extend, it wasn't permitted, so it can't be a non-conforming use. We have permits in Millwood.
It's like what I deal with every day. If it's not documented, it never happened.
Yeah. So I understand frustrations. But we also have regulations that must be followed. Those regulations are clear and you don't get to come back and say, okay, well, you know, this and that and rocks and so forth, and frankly, waste city time. So in this case, I think it's clear. We have a 25-foot setback for a 42-inch fence. He was offered multiple times for variances and other things. My understanding, counsel, is he could still come and ask for a variance, correct?
Yes.
Yes. So he has other opportunities. So, any further discussion?
No, I think it's just a case of putting the cart before the horse. And then going back, trying to rig up the cart in the right spot when you're going down the highway.
Okay.
Any other comments or discussion from the hearing body? So at this time, is there a direction to staff? Obviously, any finding you issue, we would need to write that up and bring it back for your approval, which would not happen tonight. But does any council member have a motion to direct the city to affirm the?
Looking for a motion to deny the appeal?
Yes.
Based on deliberations? I'll make that motion.
I'll second.
So we have a motion to deny the appeal that has been moved and seconded. Any discussion by the council? Any discussion by the hearing body? All in favor?
Aye.
Any opposed? Hearing none opposed, the appeal is denied, and that is that for tonight. So we have before us no further business. Do I have a motion for adjournment?
I'll make a motion to adjourn.
I'll second.
Moved and seconded. All in favor?
Aye.
This special meeting